Welcome to Jones Chase's A to Z of employment law videos. My name's Simran. I'm a trainee solicitor at the firm, and today I'll be talking to you about TUPE, which stands for the Transfer of Undertakings, Protection of Employment Regulations 2006. TUPE provides employment rights to employees where a business or a service transfers to a new employer. The purpose of TUPE is to preserve the continuity of employment and terms and conditions of employees who are transferred to a new employer where a relevant transfer takes place. TUPE is essentially a statutory novation of an employment contract. A relevant transfer can take place in one of two situations. Firstly, where there is a business transfer, i.e. the transfer of a business or part of a business from an old employer, known as the transferor, to the new employer, the transferee. Or where there is a service provision change, i.e. where an organisation decides to use another business to provide a service or to take a contracted out service back in-house. So what is the impact of TUPE on employees? When TUPE applies, the new employer cannot pick and choose which employees to take on. Individuals automatically transfer if they're employees with a contract of service or apprenticeship, they're assigned to the organised grouping of resources or employees that's subject to the relevant transfer, and are employed at the exact time when the transfer takes place. The transferee also inherits liabilities in relation to those employees who are the subject of the transfer, but also those who would have transferred had they not been unfairly dismissed by the transferor prior to the transfer. The timing of the transfer depends on the method, e.g., if the business is sold, then it's at the time of the contract completion. If it involves a service provision change, then it's at the time when the new employer officially starts to run the business. Employees do have the right to object to transferring. If they choose to do so, they won't be treated as having been dismissed by the old employer. Their contracts would come to an end naturally by operation of the law, with no statutory rights to bring any claim, nor do they have any right to any payment other than their normal contractual payments upon termination. As such, few employees typically object to the transfer in practice. So, impact on employment contracts. Well, upon transfer, the new employer effectively steps into the shoes of the old employer and takes over all the rights and obligations arising from the relevant transfer. This includes continuous service, those rights contained in any collective agreements incorporated into contracts. However, the exception to this rule concerns the treatment of occupational pensions. The new employer also becomes responsible for all employment liabilities, such as unpaid bonuses, outstanding tribunal cases, but this doesn't include liabilities for criminal offences. Notification of liabilities. The old employer is legally obliged to provide the new employer with specific information designed to assist in understanding the rights, duties, and obligations in relation to those employees who will be transferred. Failure to provide the specified information will enable the new employer to bring a claim against the old employer in an employment tribunal for compensation, as it's just and equitable, having regard to any loss suffered by the transferor. So, information and consultation. Importantly, the old employer and the new employer must inform and, where necessary, consult with the appropriate representatives of the employees affected by the transfer long enough before the transfer to enable meaningful consultation to take place with a view to reaching agreement. If an employer fails to comply with any of the information and consultation requirements, a tribunal can order a protective award of up to 13 weeks uncapped pay to be paid to each employee affected by the relevant transfer. Therefore, a failure to inform and consult can be very expensive. Employee protection. Automatic unfair dismissal occurs when an employee is dismissed or made redundant, either before or after the transfer, and where the sole or principal reason is the transfer itself or a reason connected with the transfer. Again, getting this wrong can be very expensive for the employer. Dismissal may be fair only if it can be proved that it was not because of the transfer itself, or was because of the transfer, but either the old employer or the new employer can show that there was an ETO reason entailing changes to the workforce. Recent changes to TUPE. As we know, the current position when a TUPE transfer is envisaged is that employers are required to consult with elected employee representatives on behalf of affected employees. The only exception applies in very limited circumstances where the company is able to satisfy the definition of a micro business where there are 10 employees or fewer. This year, in 2024, there have been changes to the law, and the law will expand on this exception so that there will be no requirement to elect employee representatives if the employer has fewer than 50 employees, or where the transfer involves fewer than 10 employees, regardless of the size of the employer. In either case, the relevant business transfer will be able to consult directly with employees when no existing employee representatives are in place. The transfer is taking place on or after the 1st of July 2024. It's important to note that where there are existing employee representatives in place, including trade union representatives, employers must ensure that they do continue to consult with those representatives, regardless of whether this exception would otherwise apply. For the most part, the changes serve to clarify our existing understanding of principles initially set out in EU law and considered by the courts over a number of years. However, they do indicate that the government is seeking to take steps to reduce the administrative burden on businesses while maintaining the significant legal protections available to employees. Employers should review their existing processes and policies, particularly on record keeping and the calculation of holiday pay, and ensure that they are compliant with the current position. Thank you very much for watching this video. My name is Simran Savjani and I'm a trainee solicitor here at Jones Chase. If you have any questions on TUPE or any questions on anything to do with employment law, please do feel free to get in touch. Thank you.